So I'm going to look next at some documents and guidance publications produced in the course of the 1980s, looking at what were said to be some specific ethical issues arising in the context of the AIDS crisis. The first document I'm going to go to doesn't really touch on the ethical issue. It's perhaps more relevant to matters relating to knowledge of risk of AIDS, but it's not a document I think we've previously looked at in an inquiry hearing, and therefore just worth drawing attention to more broadly. It's HCDO 5019_001. And it's a document issued by the Royal College of Nursing, headed Acquired Immune Deficiency Syndrome, and it's dated September of 1983. So it's interesting to note that the first publication along these lines comes from the Royal College of Nursing in the course of 83. It talks about the term AIDS. It identifies the presenting symptoms. It refers, if we just go a little further down the page, to the syndrome having been reported mainly in male homosexuals having a large number of sexual partners and a small number of haemophiliacs and intravenous drug abusers. And it then goes on to talk about certain precautions that could be taken in relation to protecting staff. If we look over the page, under the heading Precautions to be Taken, it refers to the hepatitis B precautions and says the same precautions should be taken when dealing with a patient suffering from suspected AIDS. Should include avoiding contamination of the skin and mucous membranes with blood products, and then secretions and excretions of AIDS sufferers or suspected sufferers, and then various precautions then set out. And then the next paragraph, nurses who are handling blood or blood products should be aware that risk is greater during the mixing of blood products in order to reconstitute them ready for administration. And then it talks about the making available of facilities in the event of accidental contamination. So not specifically an ethical guideline, but a publication recognising clearly there the association between blood products and the transmission of AIDS. I'm then going to, I should note, there are some similar publications about precautions to protect healthcare staff published by the Department of Health in the course of 1984. I'm not, however, proposing to go to those. In terms of ethical issues, if we pick matters up with a publication from the BMA in 1985, BMAL 5010_021. So this is a BMA statement. Second paragraph, the BMA Central Ethical Committee recognises that the rapid spread of AIDS has raised problems of confidentiality in the minds of some doctors. And then there's a reference to where someone's tested and is thought to have HIV, HTLV3 as a result of sexual transmission. There's a specific obligation of confidentiality under the terms of the National Health Service Venereal Diseases Regulations. And then adds this, unless the patient has given his consent, personal health data relating to him must not be disclosed to anyone for any purpose other than the health care of that patient, except where the disclosure is necessary to prevent the spread of infection. Accordingly, we have always accepted that for the purpose only of preventing the spread of infection and for no other reason, a doctor may, in exceptional circumstances, disclose relevant information with the consent of the patient. This is entirely in accordance with advice given by the Chief Medical Officer. Furthermore, our own discussions with experts treating AIDS cases have shown it's extremely rare for disclosures to be made without the consent of the patient. That's a statement in any event published by the BMA in the course of 1985. That document itself is not dated, but we've got a press statement that appears to accompany it that's dated the 13th of December 1985.
Is it intending to say without the consent of the patient in the third line there. The last paragraph.
I'm just looking at the two versions we have. I'm not sure. So I think it must be.
Because if the patient has consented, there might be, and the consent is a proper consent, there might be thought to be no problem.
Yes, actually, if we look at the press comment, which is BMAL, or press statement, BMAL 5010_020. So we can see there it's a slightly pithier statement, but in similar terms, and it's headed press comment.
Yes.
There we see we've always accepted in accordance with legislation, but that for the purpose only of preventing the spread of infection and for no other reason, a doctor may in exceptional circumstances disclose relevant information without the consent of the patient. So yes, I think it is intended to say that. So that was the BMA publication on AIDS and confidentiality in 1985. If we then go to DHSC 40177, please, Shomek. So this is AIDS Booklet 2, produced by the DHSS, information for doctors concerning the introduction of the HTLV3 antibody test. We haven't got Booklet 1 here, but that was general background information in relation to AIDS, as I recall. The date of this we see from the bottom of the page, October 1985. And there are, I think, 3 booklets in total that were issued. If we go to the next page, we can see the context is that this is a Dear Doctor letter from the Chief Medical Officer. It's dated the 1st of October 1985. And what had precipitated it was the introduction of the test for HTLV3 antibodies for screening purposes at regional transfusion centres. We look at the bottom of this page, we can see the Chief Medical Officer saying it's essential that all individuals who are found to have positive antibody tests receive counselling, both in order that they may understand the meaning of the results and to advise them how to avoid transmitting the infection to others. And then top of the next page is reference to potential availability of counselling services. And then the third paragraph says the antibody test is an important tool in the control of the spread of HTLV3 infection. If it is to be used effectively, very strict confidentiality must be maintained in respect of positive results. So that's the accompanying Dear Doctor letter from the CMO. If we go to the next page, we see the booklet itself. And if we go to page 7, again, there's emphasis there on the importance of counselling for seropositive individuals. And then if we go over the page, we see the heading Confidentiality. The strictest confidentiality must be maintained when an HTLV3 antibody positive individual is identified. And then we can see reference to again, what we saw from the BMA statement, the terms of the NHS venereal disease regulations. Unless the patient's given consent, personal health data relating to him must not be disclosed to anyone for any purpose other than the health care of that patient, except where disclosure is necessary to prevent the spread of infection. Disclosure of this information for purposes other than medical or public health reasons could lead to serious consequences for the informant. Adequate safeguards to protect individuals against unauthorised disclosure must be adopted. So that's the Department of Health talking about confidentiality. And then we can see, if we go to DHSC 303713_013, please, Shomek. This is booklet number 3. This is also autumn of 85, and this is guidance for surgeons, anaesthetists and dentists dealing with patients infected with HTLV-3. And if we just go to page 8, again, I'm focusing only on those parts of these materials that give rise to essentially broader ethical questions, but in the context of HIV, confidentiality of healthcare data. The strictest confidentiality must be maintained when an HTLV-3 antibody individual is identified. There's then reference to the same regulations. And then it says, for all HTLV-3 positive patients, the normal rules of medical confidentiality apply. And unless the patient has given his consent, personal health data relating to him must not be disclosed to anyone for any purpose other than the health care of that patient, except where disclosure is necessary to prevent the spread of infection. And then we see the bit in square brackets at the end of that paragraph. Normally it is inappropriate to test a patient for HTLV-3 antibodies without their consent, unless it's part of a clinical investigation of signs and symptoms. So there appears to be a suggestion there that it can be appropriate to test a patient without their consent, and we'll see how that debate develops over the next couple of years. If a patient refuses to be tested, then they should be treated on the assumption that they're positive if they're deemed to be in a high-risk group. And then, without going into the detail of it, if we look at the next paragraph, you'll note that this booklet then talks about isolation techniques and the circumstances in which HTLV-3 positive patients should be nursed and the facilities which they can and can't access in hospital. So that's the autumn of 85. There's then some European guidelines issued in January of 86 at SHTM 0002515. SHTM 0002515. So we see their guidelines on AIDS in Europe, produced by the World Health Organization. If we go to page 12, and if we could zoom in on the right-hand side. So bottom right-hand side, preventing the spread of infection from those known to be positive to anti-LAV HTLV-3. Testing of healthy individuals for anti-LAV HTLV-3 should be done only after informed consent has been obtained. Individuals who've been tested on their own initiative and found positive should be offered individual counselling and psychosocial support. And then it sets out information they should be provided with. They should be informed that they're infectious through sexual contact and through their blood and semen. They should be encouraged to inform their sexual partners about risk, urge to refrain from donating blood, plasma, etc., etc. But there, the first sentence, really, the importance of informed consent is there stressed. So that's what the World Health Organization had to say. We can then see the next publication by the BMA at BMAL 5031_024. So statement on AIDS. If we go to the next page, we'll see the date. May 1986, and it's a statement from the BMA's Board of Science and Education, so not in fact from its Ethics Committee. But if we go to page 12, we can see first of all the issue of confidentiality. Paragraph 1, it's vital to maintain the confidence of those in high-risk groups to ensure that by coming forward for testing or counselling, there will be no breach in confidentiality. And then it refers to a specific set of regulations, which I don't think is necessarily particularly relevant for present purposes. If we go to the next page, Go to the top of the next page. We can see there again the particular protection given to those who go for blood tests at a sexually transmitted diseases clinic because of the NHS Venereal Diseases Act, and they had to be treated under terms of strict confidentiality. And then if we go to paragraph 5 on this same page, the strictest confidentiality must be maintained for affected individuals, and then it refers to the Department of Health guidance. And then if we go down to paragraph 6 and 7, individuals with a confirmed seropositive test should inform doctors and dentists who are treating them that they're antibody positive, so that the appropriate precautions can be implemented. It's anticipated that the vast majority of HTLV3 antibody positive individuals will give consent for their own doctor to be informed of the test results. Similarly, it's very seldom found in practice that a patient will persistently refuse to tell a spouse of his/her antibody position, or who refuses permission for the doctor to contact his/her partner. In the very few cases where permission for disclosure is denied by the patient, then it is open to the doctor to contact the doctor of the partner at risk, and with this doctor's cooperation to ensure that steps are taken to safeguard the interests of both parties. And then it refers again to the position of patients attending sexually transmitted diseases clinics, doing so on the basis they'll be dealt with in a confidential manner. So perhaps a degree of tension there between the position of those who have the protection conferred by the NHS Venereal Diseases Act or regulations, and then what's contemplated here is that there would be circumstances in which one doctor can contact another doctor to pass on an HTLV3 positive result, so as to inform a partner. And again, this issue is picked up in later materials, but this is what was being said by the BMA in 1986. We can then see the heading counselling of patients after the HTLV3 antibody test. It talks about the difficulty of receiving that news. Careful counselling will be required.
In practice, it might be quite difficult to know precisely who the doctor of the partner is.
Absolutely.
And if one were to make any inquiries about that, you'd be in danger of breaking confidentiality anyway. So it doesn't look a very practical system.
It doesn't. I mean, one might be able to contemplate, if you're talking about a general practitioner, it's possible, but by no means certain, that a partner would be registered at the same practice, and the doctor would ultimately potentially be telling themselves of the position in order to then pass on the information to the partner. But if one thinks then of the kind of context that arises in many of the cases with which this inquiry is concerned, the information about diagnosis is not coming from the GP, but from the haemophilia clinician. So yes, the steps that would be involved in the haemophilia director then themselves trying to locate and inform the doctor, presumably the GP, of the spouse or partner, problematic. We then, I think, can look, still in 1986, at a publication by the Royal College of Nursing. It's NHBT 00571138. And we can go, I think, straight to page 12. At the bottom of the page, under the heading Counselling, Confidentiality and Informed Consent, individuals must give informed consent before being tested for anti-HIV. Informed consent implies that the reasons why the test is advised are carefully explained to the individual, and equally that the results will be carefully discussed. In individuals who have positive tests, counselling will be necessary. If counselling is not available, testing should not be done. The results of anti-HIV tests must be strictly confidential. A positive result may have enormous psychological implications and may adversely affect the individual's employment, marriage and other relationships. It may also preclude an application for life insurance. Under no circumstances must the results of anti-HIV testing be casually communicated to other healthcare workers, unless they're providing direct patient care, so there's an exception contemplated there. To do so would not only be illegal but also a grave breach of professional ethics and a violation of the Code of Professional Conduct of the UKCC, the United Kingdom Central Council for Nursing, Midwifery and Health Visiting. So the nursing guidance, you might think, expressed in rather more straightforward, clear, unequivocal terms than some of the material disseminated either by the department or by the organisations concerned with doctors. And in the same document, if we go to page 16, we see the heading Confidentiality. There's a reference there to booklet number 2 issued by the Department of Health. And then it looks, below that first long paragraph beginning with strictest confidentiality, it then looks at some of the practical ways in which confidentiality can or can't be safeguarded within the care team in hospital. So it says, for nurses, the main objective must be to protect the patient's identity from inappropriate disclosure both inside and outside the hospital. Access to medical records in the clinical setting should be restricted to relevant personnel. The medical record should be kept in a safe location where access can be monitored. Before discussing the patient's condition with lovers, family and friends, it is essential that staff ascertain exactly what the patient has told this important group about his, her illness and lifestyle to ensure that inquiries are answered accordingly and consistently. Currently, HIV infection and AIDS remain very emotive topics, and then reference to the social implications for the patients are immense. And then the last sentence, nurse-to-nurse communication must be confidential. We can then...
Do the relevant personnel include hospital porters?
Not sure I can answer that, sir.
Can't
think of any obvious reason why they should.
No. The word, it's the ambiguity in the sense of relevant personnel.
Yes, the question of who is relevant. It's difficult to see why a hospital porter would need to know, either for the discharge of their responsibilities or to safeguard their own health care, that a patient is HIV positive. I'm fairly confident there's nothing in the materials that we've seen that deals with that expressly.
Yes, it does arise in the evidence.
Oh, it does, absolutely. And then BMAL 5031_023. This is the BMA's third statement on AIDS. This is 1987 now. And if we go to page 16, we can see the heading consent. So it's paragraph 3.14.1. People should only be tested for HIV antibodies if they have freely consented to this and fully understand the possible implications because of the considerable disadvantages to the individual in being found to have antibodies. Consent means the ability to choose, free of duress and with the benefit of relevant information, what course of action to take. Moves to test people against their will or without their knowledge might encourage them to conceal behaviour that could place them at risk, and to avoid seeking medical attention for problems that may be wholly unrelated to AIDS. It is essential that the medical profession commands the confidence of patients and prospective patients. If patients perceive the actions of doctors as contrary to their interests, this will deter them from seeking necessary advice or treatment to the detriment of their health and will undermine the effectiveness of measures aimed at controlling the spread of infection. So there, a statement in pretty clear terms about the need for informed consent and not to test patients for HIV antibodies without their knowledge. And then confidentiality is dealt with on the next page. So the first paragraph, the traditional confidentiality of the doctor-patient relationship must be upheld in the case of patients suffering from AIDS and HIV seropositive individuals. According to DHSS guidelines, unless the patient's given consent, personal health data should not be disclosed to anyone for any purpose other than the health care of that patient, except where disclosure is necessary to prevent the spread of infection. As HIV is not spread through casual non-sexual contact, there could be very few circumstances in which disclosure would be identified. And then there's
Would be justified.
Justified, sorry. And then again, there's a reference to the NHS venereal diseases regulations. And then the next paragraph says, with counselling, the majority of infected individuals can be persuaded voluntarily to inform their GP, dentist and sexual partner of their infected status. And then in the third paragraph, it's the duty of the general practitioner to ensure that information is kept strictly confidential unless the patient consents to disclosure. Patients should be strongly encouraged to permit disclosure when there are firm medical reasons for this, such as when undergoing surgery. In general, however, the fewer people know of a person's antibody status, the more people in high-risk groups will come forward voluntarily for testing or treatment. Much of the pressure for disclosure of patients' antibody status has resulted from misconceptions about the levels of risk, which still remain common among doctors and other health service professionals. This indicates the importance of clear education for these groups. And then the next paragraph talks about insurance companies. Insurance companies sometimes ask GPs to provide information about patients who are seeking insurance. GPs should complete insurance company forms truthfully to the best of their knowledge, but should make clear to the patient what information is being disclosed and what the possible implications may be. It is then up to the patient to decide whether the form should be sent. And then some further narrative in relation to that. So that's the BMA's third statement. We've seen all the iterations of that statement in the course of 1985, 1986, 1987. In fact, yes, I think the third statement, it was printed December 1986, but it's not clear whether it was copyright 1987, so it's not clear the exact month in which it was published. There's then a GMC publication in May of 1987, DHSC 303701_028. If we zoom in a little closer, 21st of May 1987, it's AIDS, the doctor's duty towards patient. The Standards Committee of the GMC are engaged in considering the ethical implications of the control and management of AIDS. In particular, they're considering in detail the problems which arise in this context in connection with confidentiality. The committee have meanwhile drawn to the Council's attention their concern at recent reports that a few doctors have been refusing to accept for treatment patients who are HIV positive or are suffering from AIDS. And then we see the GMC setting out its view. The Council is seriously concerned at recent reports that in a small number of cases doctors have refused to provide patients who are HIV positive or suffering from AIDS with necessary care and treatment. The Council expects that the profession will extend to such patients the same high standard of medical care and support which they would offer to any other patient. And then there's a reference to, in general terms, the propriety of doctors with conscientious objections to undertaking a particular course of treatment or who don't have the appropriate knowledge, skills or facilities in referring patients elsewhere rather than treating them themselves, but then says it is unethical for a registered medical practitioner to refuse treatment or investigation for which there are appropriate facilities on the ground that the patient suffers or may suffer from a condition which could expose the doctor to personal risk. It is equally unethical for a doctor to withhold treatment from any patient on the basis of a moral judgment that the patient's activities or lifestyle might have contributed to the condition for which treatment was being sought. Unethical behaviour of this kind may raise a question of serious professional misconduct. We have that May 1987. We then have a publication in June 1987 from the Royal Society of Medicine, HSOC 0001488. This is a publication called The AIDS Letter, And we can see it's Volume 1, Number 1, June 1987. It's headed Trust and Liability of GPs in question. And it touches on the issue of confidentiality. The emergence of AIDS has forced family doctors to reconsider long-held conventions on patient confidentiality following conflicting pronouncements by legal experts. Worries about confidentiality have severely dented the trust that some patients have in their doctors. And perhaps more damaging still, the professional image of the medical profession has been called into question, with some GPs reacting with what the BMA has described as hysteria. In April, Professor Ian Kennedy, head of the Centre of Medical Law and Ethics at King's College London, told the House of Commons Social Services Committee that GPs may be sued if they do not note in their medical records that a patient has AIDS. Professor Kennedy warned that a doctor would be liable if his partners did not know of the condition and therefore were not aware of the danger posed to others, and they then advised the patient that there was no need to change his behaviour. He further explained that if a GP or locum subsequently treated an AIDS patient without complete medical notes, and part of that consultation involved a third party, i.e. lover, partner or friend, and the doctor responsible for the absence of notes would be liable. He also said that GPs could be sued, so this is bottom of the same page, if they did not advise the partners of AIDS victims that they are at risk. This amounts to a warning that family doctors must sometimes disregard an AIDS patient's confidentiality for the sake of people who may be at risk. And then there's a contrary legal view said to be put forward by a barrister in the doctor's newspaper General Practitioner, pointing out that although confidentiality is not legally absolute, it is ethically accepted that a doctor is duty-bound to keep a patient's medical affairs confidential. Any breach of that confidentiality which results in financial loss to the patient could lead to a claim against the doctor for compensation. And then I knew there was a reference to receptionist somewhere in the material, sir. This particular liability also includes surgery staff employed by a GP, and there have already been cases where receptionists, for example, have breached patient confidentiality following the diagnosis of AIDS. This is dangerous ground for GPs. Due to ignorance, prejudice and simple fear, AIDS sufferers can lose, along with everything else, their jobs. And then it suggests that the question of confidentiality for AIDS patients will remain controversial until settled by the courts. So that's the Royal Society of Medicine's publication. What we then get to in the middle of 1987 is a debate within the British Medical Association about testing patients for HIV without their consent. And we can pick it up, I think probably in a letter or a letter written to the British Medical Journal in the July 87 at BMAL 5031_027. We see bottom right-hand corner, under the heading AIDS, a faltering step. Last week, the annual representative meeting of the BMA passed by 183 to 140 votes a motion saying that doctors should be allowed to test a patient for antibodies to HIV without first gaining consent. The debate was largely concerned with what the proposer called occasional circumstances, but the motion did not contain that phrase, and nor did most of the reports in the media. The BMA thus appears to have departed from the advice given by both the World Health Organization and the Department of Health and Social Security, and in our view, the decision might do serious damage to Britain's attempt to contain the epidemic of AIDS. And if we go over the page, left-hand column, first main paragraph, the clinical, ethical and possibly legal reasons why last week's decision is wrong are worth repeating. And then the first refers to the risk to healthcare workers and says the risk of healthcare workers becoming infected is very small. And then we go to the next paragraph. The second clinical argument against the decision is that testing without consent will do little, if anything, to reduce the chances of becoming infected. And then if we go to the next paragraph, the clinical arguments for testing without consent are thus marginal, but those against are considerable. Patients who are told that they are infected when they never even knew that they were being tested may experience substantial psychological and social consequences. And who will tell the patient? Certainly anybody who considers testing a patient should be prepared to counsel the patient fully when a result proves positive. A recommendation to see an AIDS counsellor as quickly as possible is not enough on its own. The doctor who has done the test without consent is also likely to have destroyed his relationship with that patient. And then if we, there's then some background and context to the BMA debate. And then if we go to the right-hand column, second paragraph, most important of all, and here we enter the ethical arguments, when doctors say that it is acceptable to test patients without consent, they are likely to destroy the trust that those at risk of HIV infection have in doctors. We've no chance of defeating the AIDS epidemic if we do not have that trust. And then, skipping a few lines, it is a basic tenet of medical ethics that we do not treat patients without their consent, and we have to have very good reasons for breaking that doctrine, as the BMA's Handbook of Medical Ethics emphasises. In this case, we do not have such reasons, although we might have some justification in rare circumstances, and a particular example is given about an unconscious patient being assessed for intracranial disease. And then if we look at the last paragraph, the authors of this letter say, we hope very much a way can be found to ameliorate the possible effects of the decision. So that's the BMA's motion to test without consent. If we then look at BMAL 5031_035, we have what's described as a summary of the debate on motion 363 testing for AIDS. And not going to go through all the arguments, but we can just see the fourth paragraph refers to Chisholm opposing, said that the doctor is the servant and not the master of the patient. The patient must consent to testing and must understand the implications. If patients cannot trust their doctors, they will not consult or will conceal behaviour which could put them at risk. Now, that's a view being expressed, so in opposition to the motion, by a Dr. John Chisholm, who subsequently became a member of the BMA Ethics Committee and is currently the chair of the BMA Ethics Committee. And he's kindly provided a statement to the inquiry giving his context, giving his perspective on the debate that the BMA held. And if we can just look at that, it's WITN 5507001. If we go to page 5, please. We can see the heading there, Annual Representative Meeting Resolution of 1987. I'm asked to describe my involvement in the 1987 Annual Representative Meeting of the BMA, and in particular my recollection of the discussions relating to and conclusions reached about the resolution that testing for HIV antibodies should be at the discretion of the patient's doctor and should not necessarily require the consent of the patient. And then if we go to the next page, he describes various other debates taking place about HIV, and a motion, this is the top of the page, that had proposed that if someone was found to have HIV antibodies, then irrespective of consent, their GP, other medical practitioners and other healthcare professionals might be told of the result. And then he says this, I was not to my recollection called to speak in that debate. However, it was very apparent to me while it was taking place and during the other debates in the session that significant numbers of speakers and of those present were in favour of circumventing normal consent procedures and breaching patient confidentiality through the taking of blood without consent in order to test for AIDS, despite this being unlawful. Some contributors to the debates were seemingly more concerned about protecting healthcare staff from the risk of infection than about the rights of patients. My own position was that the normal principles of consent and confidentiality should be applied, and that all healthcare professionals undertaking exposure-prone procedures should take precautions with all patients to avoid or minimise needle stick injuries and risks of cross-infection. We go to the next paragraph. The BMJ report is accurate in its reporting of the tone and nature of debates. My recollection of the session on AIDS is that it was undoubtedly the most dysfunctional, confused, unruly and at times heated session I have seen in more than 40 years attending annual representative meetings. He refers then to someone losing control of the meeting, and then he says the ARM resolution was passed against the clear and correctly ethical wishes of the chair of the Council of the BMA. To my mind, the debates had given a poor impression of the ethics and attitudes of some of those contributing in the presence of journalists from national print and broadcast media. And then if we go to the next page, paragraph 10, Dr. Chisholm describes how he was asked to go on TV and be interviewed for the BBC Early Evening News to try and ameliorate the damage done to the BMA's reputation caused by the resolution and the wider debate on AIDS, which had included speeches in support of the breaching of patients' confidentiality in order to protect doctors. And then the last sentence of that paragraph, it was very clear to me that the policy not to seek patients' consent and the threats to breach patients' confidentiality were ethically indefensible and that the policy would have to be revisited. And then if we go to the top of the next page, picking it up in the second line, it was my view at the time, as I expressed in the debate, and remains my view, that testing without consent, let alone routine or indiscriminate testing for HIV without the patient's consent, was not just inappropriate, but wholly unethical. Sets out his views in no uncertain terms. So the reason, in part, for drawing attention to that is not just out of, as it were, historical interest, but because you'll recall that some clinicians, certainly in written, and I think probably oral evidence, have referred to the BMA debate that took place in the passing of the motion to suggest that there was a degree of support for a practice of testing without the patient's consent. And therefore it's interesting to see the view of Dr. Chisholm, and indeed what we're told was the position of the chair of the Counsel of the BMA about the nature and inappropriateness of that decision.
Well, there's another side to it as well. This raises the profile of the question of consent for testing. And it means that those doctors who were a party to the decision, one way or the other, would have a view on it, and the profession were pretty well bound to be aware that there was a big issue. And the policy changed shortly after that, didn't it?
It did, precisely so. So following widespread, I think, expression of concern within the profession about the passing of the motion, the BMA sought sought legal advice from Michael Sherrard QC. We have his advice at BMAL 5013_033. Now, obviously, he's talking about the legal position. Dr. Chisholm was talking about both the legal and the ethical position. But in terms of the legal position, Mr. Sherrard's advice is pretty unequivocal. He says, and while it must be appreciated that such effect as the resolution may have is limited to the domestic policy of the BMA, possibly disciplinary proceedings before the GMC, it does not affect the law of the land. And then he talks about the fundamental principle of English common law that every adult human being of sound mind has a right to determine what shall be done with his own body, and talks about the tort of battery and of assault. And then 3, it will be apparent, therefore, that any medical treatment which involves physical contact with the patient's body is a potential battery. It's the existence of the patient's consent to the touching which renders the touching legally unobjectionable. We shall use the term treatment to include testing in this context. And then there's a discussion of consent. As a general rule, the consent of the patient is an essential prerequisite to medical treatment of any kind, even that of a relatively minor nature. And then there's a discussion over the page of various cases. Bottom of the page, under the heading implied consent, we pick it up in the end of the third line, in our opinion, the doctrine of implied consent is not at all likely to be held to cover testing for HIV antibody. The taking and testing of a sample, although it may be commonly be carried out, would not, in our opinion, be considered routine by the courts. Given the far-reaching implications of a positive result, it cannot reasonably be contended that an HIV test can be covered by the notion of implied consent. And then that paragraph ends with, accordingly, a medical practitioner is under a duty to ensure that the patient's explicit consent to the testing is obtained. There's then a discussion about the legal requirements for informed consent. We go over the page. There's then a heading of some further practical considerations. And then we go to conclusions, bottom of the next page. The implementation of the resolution under discussion has the potential for placing medical practitioners in an extremely difficult position. As the law stands at present, the consent of the patient is essential if the act of taking a sample for testing is not to constitute an assault or expose the practitioner to a claim in negligence for failing to inform the patient of the nature of the test and possible consequences of a positive result. This leaves aside any questions of professional misconduct which may arise. And then paragraph 13, it's clear the courts will strive to uphold the individual's bodily integrity. Paragraph 14, we're of the opinion that where in essence a medical practitioner has, without the genuine consent of the patient, obtained a blood sample for the predominant purpose of testing for HIV antibody, the courts are likely in the end to accept the formulation expressed by Lord Scarman in the course of his speech in the Sidaway case. And then bottom of the page, in the final analysis, it is our opinion that the courts will continue to hold that the right to decide rests with the patient and not with his medical advisor. It would be unwise for practitioners to adopt a course which preempts possible legislation and exposes them to both criminal and civil proceedings. And that's the conclusion. The date of the advice, September 1987. The advice was effectively accepted by the BMA and promulgated by the BMA, and we can see that at BMAL 5031_067. I won't go through it. It's essentially the text of the advice that was published by the BMA. And subsequent publications by the BMA made clear that they did not stand by the motion 363 that had been passed. Just in terms of publications then emanating from others, and I take this fairly shortly, but again it's instructive to see what the UKCC said, what the Nursing Council was saying. BMAL 5029_013. AIDS testing, treatment and care. So we can see this refers in the first paragraph to the BMA's the BMA's decision at its annual representative meeting, and then says on the specific issue of the taking of blood for testing without consent, the Counsel, so that's the Nursing Council, has advised nurses, midwives and health visitors on its professional register who have approached it, and now advises all its practitioners that they expose themselves to the possibility of civil action for damages or criminal charges of assault if they personally take the blood specimens, and of aiding and abetting such an assault if they knowingly collude with a doctor in obtaining such specimens. Additionally, these actions, like that of being a party to any statements aimed at leading patients to believe the blood specimens taken for AIDS testing were for some other purpose, expose nurses, midwives and health visitors to the possibility of complaint to their registration body alleging misconduct which would put their registration status and right to practice at risk. So, in no uncertain terms, the Nursing Council rejecting the BMA position. There are later and more detailed statements issued by the UKCC which reiterate, again, that position in no uncertain terms. And then I think probably the final document that we can look at is a GMC publication in May of 1988 at NHBT 0010410. This is the GMC's document, HIV Infection and AIDS, the ethical considerations. And again, this was updated over the course of the following years. And if we look at page 2, under the heading, the doctor-patient relationship, paragraph 2, the doctor-patient relationship is founded on mutual trust, which can be fostered only when information is freely exchanged between doctor and patient on the basis of honesty, openness and understanding. Acceptance of that principle is, in the view of the Council, fundamental to the resolution of the questions which have been identified in relation to AIDS. And then if we go to the bottom of the next page, there's an articulation in paragraph 12 of the general principles that a doctor should treat a patient only on the basis of the patient's informed consent. Doctors are expected in all normal circumstances to be sure that their patients consent to the carrying out of investigative procedures involving the removal of samples or invasive techniques, whether those investigations are performed for the purposes of routine screening or for the more specific purpose of differential diagnosis. There's a recognition that there can be circumstances of where a patient might agree to provide a specimen of blood for multiple analysis. But then over the page, the Council, the General Medical Council, then applies that principle to testing for HIV and says this: the Council believes the above principle should apply generally, but that it's particularly important in the case of testing for HIV infection, not because the condition is different in kind from other infections, but because of the possible serious social and financial consequences which may ensue for the patient from the mere fact of having been tested for the condition. And then there is a further discussion emphasising that point. Should just note the last sentence of that paragraph: only in the most exceptional circumstances where a test is imperative in order to secure the safety of persons other than the patient, and where it's not possible for the prior consent of the patient to be obtained, can testing without explicit consent be justified. And it's, again, it may be difficult to think of circumstances other than the unconscious patient where the nature of the surgery or investigation that's required is such that people will be placed at great risk if the status of the patient's not known. But that's probably about the only thing that might come within that very limited exception they're given. And then there's a reference to confidentiality in 2 paragraphs further down. So these publications from the BMA, the GMC, and so on were then reissued over the following years in broadly the same terms with respect to issues of consent and confidentiality. I should just draw attention to, though I'm not going to go to the documents, not least in view of the late hour, to the fact that there was in 1990 and then I think in 91, 92, there was an exchange of statements or various statements being published contemplating that there might be cases in which surgeons should be allowed to test patients without their consent for HIV so that the surgeons would not be placed at risk. So the Royal College of Surgeons in Edinburgh published a statement in March of 1990 which identified circumstances in which it was said it might be appropriate to test patients without their consent. There was a responsive statement from the GMC saying that could really only be in the most exceptional circumstances. And then a further statement from the Royal College of Surgeons in England in January 1991, touching on the same issue. And in March 1992, a further statement. There apparently limiting what was said to be the circumstances in which testing without consent could be undertaken to the following scenario: if the surgeon or other member of the operating team receive a serious injury during treatment of or operation on a high-risk patient in whom the serological status is not known, it was their view that the surgeon had the right to test the patient for HIV whether or not the patient had previously given consent for testing, and that then after the operation the patient should be told that. Whether that's a scenario that ever in the real world occurred is not something that the documents themselves tell us. So finally, on this issue, and without needing to go to the documents, 1993 then saw the BMA in its medical ethics, practice and philosophy document. We've looked at that, the long sections on consent, confidentiality, had a specific section on testing without consent for HIV, strongly opposed to that, made clear its view that HIV testing without consent should not take place. And the GMC updated its guidance on the ethical considerations in relation to HIV and AIDS in 1993, again emphasising that HIV testing required patient consent even where blood samples had already been taken for another purpose.
It was that last matter which I wanted to ask you specifically about. Is that the only reference that there is which might touch upon the question of whether blood samples taken for one purpose or for a generality of purposes, none of which, on the information known to patient or doctor at the time, might have involved testing for HIV, should and could ethically subsequently be tested for HIV without the patient knowing?
I'm not sure without checking, sir. I certainly don't think there's anything which says that, which says in positive terms that that's an ethically acceptable course of events. The extent to which the publications say in positive terms it's unethical is what I would need to check. Those are the documents that related specifically to some of the broader ethical issues as applied to the emerging AIDS crisis in the 1980s. The very last topic in our note, I'm not going to go to any documents now because I think we can probably usefully pick it up at a later hearing, was about the relationship between doctors and pharmaceutical companies and the circumstances in which doctors can or cannot accept hospitality, gifts and the like from pharmaceutical companies. But it may be that only a handful of documents that we would need to look at in that regard, but it may be that when we have our autumn hearings on pharmaceutical companies, we can look at those materials then.
Yes. Yes, thank you very much. So we are not involved in hearings next week.
That's correct.
And the week after?
The week after, we begin our hearings on the Tuesday, which is, I think, the 8th of June.
It is the 8th.
And we hear Tuesday, Wednesday, Thursday, Friday of that week from a number of campaigners, most of whom will be giving evidence in person, not all, some are giving evidence remotely. And then the following week, we conclude that, and then we return to the topic of haemophilia centres with a presentation looking at a number of the smaller haemophilia centres or non-reference centres that we haven't explored in the oral evidence so far.
So that's what the next 3 weeks has in store, the first week being a break. And I hope everyone has the opportunity to enjoy the bank holiday weekend and the next week's break, as we would have it as a break, as best they can.
Thank you, sir.